Hey guys, welcome back to another episode of Let's Discuss Cafe. Today we are thrilled to continue our insightful conversation with Mr. Chetan. He is a FOSS Compliance Counsel at Bosch. For people who may not know what FOSS means, it is actually an abbreviation that stands for Free and Open Source Software. If you missed the part 1 of our conversation with Chetan, make sure to catch up on our fascinating discussion about intellectual property law and open source software compliance. Now let me tell you a little bit about Chetan. He's an alum of IIT Kharagpur. He has an impressive background that spans from software engineering, patent analysis to legal research. Today, we dive deeper into his experiences and his thoughts on evolving landscape of software licensing and compliance. Stay tuned for a compelling dialogue. So Chetan, welcome again. Thanks for appear on the second part of the podcast.
Thank you for having me.
So for the listeners who don't know Chetan, please go and listen to the part 1. We have given an amazing introduction to what Chetan does and what kind of things he's on a day-to-day basis. Just a quick refresher, he is FOSS Compliance Officer at Bosch, right? Do you want to just give a quick explanation what is FOSS Compliance Officer do?
As a FOSS Compliance Officer, my part of the job is to ensure that whatever software component we are using in our product, they are compliant with the open source licenses.
Can you state what FOSS stands?
So FOSS stands for Free and Open Source Software. So there are two major organizations which deal with the open source in general. One is Open OSI, that is Open Source Initiative, and another one is Free and Open Source Software, FSF. So the FOSS is basically a combination of both these two. So OSI has a different understanding of what open source means, whereas Free Software Foundation have a different understanding to me. So any application which is licensed under developed by Free Software Foundation are considered to be a free softwares, and anything which is licensed under Open Source Initiative licenses are known as open source licenses. So collectively, they are known as FOSS.
Right. That's great. And in the last podcast, you explained it really well. Like, just because something is available on internet for free, it doesn't mean it's open source.
Yeah.
And because you have to pay for some software, it doesn't mean that the software is not open source.
Yes.
Want to retrieve that for our listeners?
Yes. So the best example is Wikipedia. So if you look into the Wikipedia and scroll down, you'll see Creative Commons Attribution Share Alike license. So what it means is that although you have right to use this particular work, reproduce that work in your whatever the thing that you are doing, but that does not mean that particular piece of work do not have copyright of someone. It is still copyrighted by someone. Somebody owns that piece of work. He can change, he can do whatever he wants to do with this piece of work. But out of his goodwill, he has given you the right to use, reproduce, create derivative works out of it, but with certain conditions. Now, those conditions are under Creative Commons Attribution Share Alike licenses, that whenever you're using work which is under this particular license, you need to give attribution. Now, attribution is nothing but the copyright notice, means the name of the author, copyright sign, year, and then all right received, and so whatever. Second, share alike, what it basically means is the way you received it, you shall reproduce it in the exact manner. You cannot make modification to that work. So for example, if I downloaded an article from Wikipedia and I want to republish it, I cannot make changes in that work as per the license agreement. Apart from that, there are various licenses which says that you cannot charge for the application itself, but if you want to give maintenance and support, you can charge it for that. Or if you are distributing in a conventional manner, for example, CD, DVD and all, you can charge it for that. Or if you are adding your own application along with it, then you can charge it for your application, but not for the something that you have received from us. So yeah.
So see, this is what a lot of lawyers say to me, that they say like, okay, we were just starting to understand what is an open source software. You brought in the concept of free software, and then you create a distinction in that. While explaining that, you brought in the concept of Creative Commons, right? So now explain the stuff to me. You are now you have like, let me just rephrase what you have just said and correct me if I'm And open source software essentially means that the source code, like, that the thing that coders have actually written, that is available, open to everyone, right?
Yes. Yes.
Just because it is open to everyone, it doesn't mean that you can do anything with it, right?
Yes.
So you can open source your software under two frameworks. First is software initiative, and the second one was?
Second one is OSI.
Okay.
Open source initiative.
Software foundation, and the other one is open source initiative, right? So you can know these, and they have these attached with it, right? And
Yes.
for legal audience who really understand copyright, this is not for you. For a general audience, copyright is like a bundle of rights. So you have rights, right?
Yes.
Now you can begin. Which one do you want to access, right? The right to ownership, right to reproduce, right to accreditation, right? There are so many rights. So in these, what is happening is these foundations and these organizations are standardizing these licensing terms essentially according to their own interpretation. Now, there is another thing that comes in, which is Creative Commons, which is nothing else but a standardized versions of licensing terms.
Yes.
Right? And what is exactly Creative Commons? I will let Chetan explain a little more.
So Creative Commons is a set of licenses which is basically designed to cater the requirement of artistic work. So if, let's say, I have a sound recording or a image or a text, and I want this piece of work to be protected under copyright information. So now under open source, whatever the licenses we have, whether MIT, BSD, GPL, so all these licenses are designed for software specific in nature, right? So you will find some technical information there as well. But Creative Commons is designed in a way that it only caters to your artistic work. Like, for example, an image or a text, which is Wikipedia, or any sound recording. But during my course of work, I found out a lot of authors, they have also licensed their work under Creative Commons as well. Now, Creative Commons comes in a very... Sorry, yeah.
When you say authors of software or authors?
Yes. No, authors of software. So these licenses are there on their website. So Creative Commons have a huge website where they give you a variety of licenses. Similarly, Free Software Foundation has their own list of licenses, General Public License 1, General Public License 2, General Public License 3, which is their latest version. They also have something known as Lesser General Public License, LGPL 2.1 and 3. Then they also have Afro General Public License, that is AGPL. Similarly, Open Source Initiative, what they does is they look at the license text which is designed by a specific author, go through the license text, determine whatever the principle they have enshrined in a license, whether those principles are there or not. If they found those principles in that particular license, they certify it. So OSI is sort of a certification body which certify the licenses, whereas Free Software Foundation is something which draft their own licenses. Talking about the Creative Commons, so Creative Commons in general comes in a various flavor. So they have 4 or 5 terms. So first term is Creative Commons attribution. Now, Creative Commons attribution is something where you can use the work, do whatever you want to do with the work, just attribution is required. Now, with the same thing, they add another term that is Creative Commons attribution and share alike. Now, the moment I add share alike, it becomes a sort of strong copyleft. Although the term is not correct to use here, but in a way, it becomes the strong copyleft, means you need to distribute the work in the same manner. Now, it's up to a person who is licensing his work under Creative Commons to either choose this share alike or not. Then third thing comes, let's say, for example, I wrote a novel and I do not want commercial people to utilize it. So I can do Creative Commons attribution non-commercial. So the moment I do this, what happens is you cannot use my work for commercial purposes. So Creative Commons have various things. So one is share alike, another is your non-commercial. I think these are the two major ones where you can customize your license as per your requirement, and you can release your work under these requirements. Now, apart from that, they also come up with the various jurisdiction specific. So, for example, I am the person who wrote some article in US and I want that article to be judged in the US jurisdiction. So, I can go with Creative Commons, share alike or whatever, USA. So now by that, what happens is whatever the list of rights, obligation and restrictions are there in the license, they shall be interpreted in terms of United States of America or Canada or anywhere else. So Creative Commons, I would say, is sort of a la carte basket where you choose rights and obligation as per your requirement and then release it to the public.
It essentially makes the job of lawyers redundant. Like, you don't have to consult a lawyer every time you are doing a licensing of your software, right? And this is a very boring and mundane topic as to what these. So we'll not go into the detail of this in this podcast. But a friend of mine has written a very extensive article on this. So really interested in understanding the nuances of each and every license. I'll put a link in the description. You go and read that. Right. Now, moving on to the next very interesting question, because we're talking about softwares. Patent for software, right? Current scenario versus how things were 5 years or 10 years back, or patents of software in India compared to software patents in the US. Like, do you want to give a comparative analysis on this?
Okay. So patent, if I talk about patent in general, USA versus India. So patent grant in USA is more easier when it comes to these things. So they more or less give everything patent, right? Because they are more market-driven economy. When we talk about India, we more or less follow the approach of UK or Europe, where we are very selective in order to give exclusive right to anyone. Now, coming to the software part, in USA, you can get a patent for more or less anything, as long as it is not computer program per se. So now per se can be interpreted as in you have an algorithm, you convert that algorithm into a machine readable language, either in Java, C, C++, whatever. Now in India, what basically happens is that you will not get patent for that particular code itself. Rather, you'll get the patent for functionality it achieves. So if I take an example here, let's say I am developing a washing machine, right? Now this washing machine has certain features. Feature as in you press a button, it will wash your delicate clothes in a certain manner. Or you press a button, it will wash your woolens. Now this functionality is achieved by a software, right? So when I press delicate, it will give certain inputs to the hardware, and then hardware function in certain manner. Now I can get patent on this particular software along with the functionality. If I go and say, okay, this is my software and give me patent for this software, I will not receive it. I have to show how it is functioning and how it is enhancing the either the monetary way or enhancing the life of the people in general. So in India, if you want to get your software patented, you need to show the functionality associated to the application. Means there has to be somewhere hardware and software linkage, and how this software is controlling that hardware to either assisting people or reducing money.
Wow, great explanation. And do you want to delve into why inventors or companies love software patents versus copyright? Like, just FYI for people who don't know, copyright software or source code is created as a literary work, and by the virtue of Berne Convention and the Indian Copyright Act, you get automatic or protection of it as soon as it is put in a tangible form. There is a perception that if you don't register, it would be it's not enforceable. No, if you don't register, it is harder to enforce. But the moment you put it in a tangible format, it is protected.
It is protected, yes.
Right. Now, the question: why they love software patents versus software copyright?
Okay, so it's almost 2 years since I'm working in this industry, and I read a lot of research paper, and I also work with the software developers. So one thing which I found out after this year of experience is that software is something which is very functional in character, right? So whenever I want a protection, I want the protection for the functionality, not the expression, right? I am least bothered about my expression because there are n number of ways someone can copy that expression and still that expression is different from mine, right? Now, copyright is designed in a way that it only protects the expression, not the functionality. Whereas patent is something which protects your functionality. They are least concerned about the expression, how you are expressing it. So I think this is one of the reason because of which companies are preferring to go for a software patents rather than copywriting. Now, if I deep dive into this, then I would say in copyright, what happens is if you have multiple way to express certain things, right, then your expression is protected, right? So for example, I'm developing a software for scientific calculator, let's say. Now in developing that scientific calculator, no matter how well I have written that piece of code, but if it's the only way to achieve the addition of two numbers, someone else can copy it, right? Either I have a copyright over it. Now, because of this particular reason, people are preferring patents. Now, in patents, there is nothing like such. So if I am the first inventor of an application and filed a patent for my software, nobody can touch me. Nobody can touch my product. Nobody can even use it or import it. Same sort of thing is not available in the copyright. So copyright is designed in this way. There is one beautiful paper written by, I'm not sure who's the author of it, known as Spillover. So he basically discussed about the fallacies of the copyright law. He said the copyright is designed in a way so that it has a lot of fallacy in it. Apart from that, I also believe that comparing a novel with the software is the right thing. It's like comparing apple with, I would say, a potato. They are not even the same family altogether, right? Apart from that, one more reason because of which I believe copywriting software is not well protected is if you look into the time period. So copyright is given for authors like 60 years, right? And nowadays, the technology is fasting such a way that today my software is in market, tomorrow something new comes and it become obsolete. Now, what will I do for that particular protection? So, yeah. And there are a lot of research paper written by a lot of people. I think Pamela Samuelson, she's a well-renowned professor in UC Berkeley, if I'm not wrong. She has written a fantastic paper where she has discussed that why copyright is not right legislation to protect softwares.
Right. And, from a practical perspective, a lot of people who are writing software, they come to me and say if I want to register a software, right, I have to submit a copy of it, right?
Yes.
That again, that to me, to an author of a software, that seems more risky because I'm sharing my copy and I'm making it public domain. If I'm so secretive about it, I'll rather just keep it, a closed source and keep it as a trade secret. Yeah, and protecting it in the form of the copyright, right?
I also believe that proving patent infringement is comparatively easier than proving the copyright infringement, right? So when you go for a copyright infringement, a lot of things. Firstly, you need to show that whatever you have done, this is the fact part of it, and these are the expression. Now, in that expression, they will look into the substantial similarity, right? So whatever the work I have, in whatever the work infringer have, they will look for the substantial similarity in that. So they design in such a way that at last, whatever is left, most of the time it is not considered as infringement. So I don't think so copyright is doing any help to the software industry. It's a high time that we look for some new legislature which is more stronger and stringent. On the same time, give protection for a limited period. I mean, don't give us protection for 20 years because technology will be obsolete in 20 years. Give us for 5 or 7 years and has to be a stronger one than copyright specifically.
Expedite the
process, yes.
The patent granting process. And a couple of years back, I think till 2015, 16, when I was actively practicing IP, right? At that time, the position of Government of India was that we will not grant just the software patents, right? We will grant patents if a software is attached with a novel hardware, right? That was the exact term these guys was using. Now, result of that, what is happening is that, for instance, imagine that I want to get a patent for a software which helps people in restaurant order their stuff right from the table they are eating at, right? So, I want to create a software like that. Now, in India, I can't get a patent for that software, right? So what I'll do, I'll just for the sake of getting a patent, I'll attach a software, attach a hardware, I'll attach a basic computer which is not novel in any way and try to get a patent that way. So do you have any latest updates on it? Is this stance has changed or are they still following it?
No, I don't think so. They have changed anything on this particular matter. And to be honest, and it won't be an exaggeration to say that we basically wait for US or UK to do something, and then we implement that in our legislation. So although they have changed the rule, but I don't think so they have made any changes so far as granting the patent for the software in general. Software patents are usually granted in India. It's all about the way you are drafting it. A very experienced drafter can get you patent on any piece of software. Just a misnomer now that software patents are not there in India. It's all about the way you are drafting it. If I can recall correctly, a friend of mine, she used to work in one of the industry, and she drafted a patent, and the functionality for which she get the patent was very, I would say, naive.
Right.
I mean, they have a drop-down menu initially. I mean, they had a ribbon initially, and then they converted that ribbon into a drop-down menu, and they drafted in a way that it reduces the time for the consumer. It is easier to see, and so on and so forth. And they received the patent for it. So nowadays, I mean, you are getting patent for anything and everything. It's just that how you are drafting it.
Right.
Thus, there shall not be any prior art, of course.
Right. So it brings us to a very interesting concept as to what should young startups at this stage do, right? So, because, like, to be honest, like, as a startup, a lot of times we come up with the new ways of doing stuff, right? Especially when there is an emerging technology, right? Now the question comes, what should they do? Should they invest 2 lakh, 2.5 lakhs? Like, this is the minimum amount a decent patent specification drafter would charge, right? Get that, and just for the sake of as a competitive advantage, which sorry, should I say as a mode to self defense, we can just get that patent in India, or get it in the US, or should we like ignore the patent part of it, focus on the building product?
So I would say that if a startup is in a very nascent phase and whatever the technology they have come up with is not so revolutionary, I believe that keep on working on it rather investing their time on patent. The best way is if they have something which is like revolutionary, nobody has thought of it before, then of course you should go for a patent. Otherwise, no point of going for the patent, right? So let's say I develop something and somebody develop the same thing. Now question comes, whether I'll go for a patent infringement there or not, right? If they develop more or less the same thing, do my purse allow me to go for a patent infringement? So all of these things do come in picture. Whether to go for a patent or not, I would say it's best suited on either the purse of there. I mean, how much money they have in their bank account, plus the nature of technology they want to protect. Like if it is something which is very unique, then of course they should go for. I mean, it's all up to the money they have in their bank account. People often file patents just for to file case against other people. So
these people are called patent trolls, right?
Yes.
That they will have a company who is not doing any business.
Yes.
The company just hold on to a lot of patents and just go and filing cases against.
Yes.
And because litigation and IP litigation is quite, and specifically IP litigation is quite expensive in the US. What lawyers, what end up happening, that majority of the cases are settled.
Yeah. So that is what is the case I've seen even in the open source as well. So there are a lot of companies who had to settle their cases outside the court and paying a hefty sum of money for something which is very, very small. I mean, they're not supposed to pay that much. They could have done it in the initial phase, but because of lack of information, they have not. So for patents, I believe, as I said earlier, if your purse support, then of course go for a patent. If your technology is very unique and could have a disruptive effect on the market, then of course go for a patent. But if it is something which is like in general, like general in nature, then I would say there is no point of wasting your money on getting the patent, because you are not anyways going for the patent infringement or anything else, because litigation in India is still a very expensive and a tough job.
For all reasons, right? And see, that's exactly was the experience of one of my friends, and he was sued by company which is offering an open source solution, right? So that's a misnomer that people don't believe that, and that's why in the last podcast I was like, trying to tell you as to how, like, young startups can make sure that, they're not infringing the open source licenses for so if you like end up in a problem and like they are asking for an FTA money, try to get in touch with us. We will probably try to help you as much as we can.
Yeah.
But for our listeners, that now see that's now coming back to your question as to what they you said like they should get it patent if the technology is revolutionary, right? At the early stage, it's hard to guess that, right? I mean, imagine this, like imagine this: we are let's go back 20 years or 25 years back in time, right? Now imagine the founders of Google is sitting in front of you, and they're asking, Chetan, now what we have done is that getting inspiration from academic papers, where inspiration is a very good indicator of the fact that how credible a scientific paper is. Taking inspiration from that, we have tried to implement that this concept in the web itself. So now we are going to categorize or rank a web page based upon the fact how many backlinks and what is the quality of those backlinks is coming, right? Now, the guys come to you, right? And what would you say to them?
I mean, Google didn't go for a patent for it anyways, and still they are doing absolutely fine.
That's luckily true, but yeah, there is no necessity, right? Right now, the thing is, when Google was trying to do, IBM wasn't trying to enter into the search engine market, right?
Yeah.
What is happening is that because a lot of people in respect of generative AI is coming to me and saying that, this is the things we are doing, should we get a patent or not? But the problem right now is all the existing incumbents, whether it's Google, whether it's Microsoft, it's Apple, all of them are trying to enter into the, and even NVIDIA, right? So now, like I'll give you a very practical example. A couple of days back, very good friend of mine came to me, and these guys have come up with the method or process through which they can substantially reduce the hallucination problem in the large language models. Obviously, I will not go into that because then it will become part of prior art and it will invalidate their patent application if they decide to file, right? So for people from non-legal background, if you have certain idea about the patents, you can definitely discuss this internally. You can definitely discuss it with your lawyers or loyal friends, but never publish it, because the moment you publish it, it becomes part of the prior art. And that is a very, and if that happens, it's almost
invalidate your own invention. I mean, yeah. So there are anticipation clauses there, but then again, unnecessary hassle will be there.
That's again a complication. So don't publish it.
Don't publish. That's a end line is
right. So now the thing is, now a person like me, is like these guys are doing hard work. They are obviously on a shoestring budget. They have done a really good job at reducing the hallucination problem, which is a very fundamental problem of large language models. So what should I say to those guys?
So if the application which they have developed is actually affecting means reducing the hallucination in a large language model, I believe this is a revolutionary technology. They should go for a patent for this particular application. Now, when I say general in nature means, let's say I develop a new device which use AI to do specific tasks. Now, this is something which is very general and very specific. I shall not waste my time to get a patent for this. Now, the example which we have given is resolving a very technical problem which is there, and most of the AI model are suffering from it. Now, this is a revolutionary technology, I believe, and they should go for the patent for this one. Well, so you need to identify and determine or rather I should say, weight your own invention on one end and the amount of money that you are willing to spend on the other end. Now, if you find that money is well spent, then yes, go for it. But if you see it is not, and you are running low on the budget, I would say save your money. That is the best way to go forward. But this technology, I would say, of course, you should go for it.
See, that's exactly was my advice as well. So that's pretty interesting. And now we're talking about large language models, ChatGPT. What is, in your opinion, as an ex-engineer and a current lawyer, what is the best use case for generative AI in the legal profession?
In the legal profession, see, interpretation is a major role that lawyers do, right? And I don't think so the current AI or the generative AI that we have is sufficient or capable enough to do the interpretation. as one of the law professor put it in a very well-mannered statement, is that these generative AI are nothing but text prediction, right? So what I have in my mobile is more or less the same thing, but on a larger scale.
The right quote is, they are over glorified autocorrect.
Yes, over glorified autocorrect, exactly. So as of now, with the current state of generative AI, what the assistance they can do in the legal field is the drafting of the contracts, especially the normal contracts, for example, rent agreement or the sale deed. They also can help you in analyzing these agreements. Means if I want to get the summary of an agreement, I can go through. But then again, I would highly recommend not to rely completely on the summary provided.
Right.
So on the drafting part, I would say that yes, generative AI can assist a lot.
Yeah.
But still, there are a lot of areas where, especially in the legal domain, AI is still not on even the closest pedestal, I believe. Right. So the reason I believe is when we talk about law and core law in general, it's more about the interpretation. If I take an example of a criminal law, let's say somebody stabbed me. Now here, the question is not that person has stabbed me and that's why I'm a murderer. The point comes into what pressure, where I put the knife into, whether that knife hitting the vital parts of my body or not, how much I twisted the knife, right? So evidence comes into a picture, and I believe current state of the AI is not able to handle all of these things and is not able to predict the answers or determine whether the person is guilty or not of the crime he is accused of. So in drafting part, I would say yes, AI can assist. On the analysis part, of course, AI can assist, but still a lot of work is still lawyers need to do.
Right, absolutely. So this is like, in a sense, you were saying the interpretation is a use case where I feel that AI is really lagging and there's a lot of work we do. Like that's completely, I completely concur with you on that topic. Right. But in addition to these general use cases like contract drafting, contract analysis, or contract review, do you have any specific to the kind of problems that you are facing, right? Very specific to professionals who are doing your kind of work, where you feel generative AI can make a huge difference?
I won't say that I'm working into this particular area, but yes, there are a lot of people who are doing the drafting part of the agreement or the analysis part of the agreement.
I'm also
yeah. So for them, it's really helpful. Just for the fun sake, I try to create a question answering model to see whether they are functioning, they are sufficient, whether they will assist me or not, although it's not my part of job. So I was able to determine exactly what are the rights and liabilities of the obligation, at least where it is stated, or classify the entire license agreement into the pre-informed clauses. So yes, on that particular part, of course, the AI can help you. But then I would say second reading is still required because there are a lot of things which even in my model that AI left. So if I ask from the right, there are certain things it provided, then certain things I still have to go through the entire license agreement and then look into.
Have you used any AI for legal research?
No, I don't rely on AI for legal research. I go on SSRN, look for a legal research, and then start reading into it.
That's true, but just to remember, right, that the lawyers before your generation used to say the same thing about Google, right?
Yeah.
Remember that.
Yeah, I still believe that books are a better way to go forward. I have a lot of legal books which are kept outside. Even if I have to, sorry to cut you, but
no. So like that's what like books. I completely agree. But like imagine today, like I have this question, right? Whether having an indemnity clause with 3x liability, right, or something of that sort, right? Where would I go and do the research on this? If I would have to go to the old school and do the research just by using books, how would I go about that?
Drafting a indemnity clause or
legal research using books, right? And I have a legal question whether this indemnity clause is valid or not, right? How would I go about it?
I think for contracts specifically, there are a lot of good commentaries available. I believe I think Holla or Holla is one. Holla in Holla, I believe. Not Holla. There is some book from Nexus. LexisNexis is there, which has a huge commentary on contract law. And those commentary are given on the section specific. So you go and find the indemnity section.
Right.
What is the section number for the indemnity? Open that book, go to that particular section and go through the entire case laws, whatever is there. And I believe if you read 5, 6, 7 research paper, after 7th, you develop this ability to read few lines and determine whether this particular paper will be helpful to you or not. So once you do that research, you will able to develop this capacity that after reading few lines, you will determine, okay, this is not useful for me, I can move forward. So yeah, that's what it is. And I still believe that is the best way to go forward.
Okay, makes sense. So Chetan, thanks a lot for coming on the podcast today. Again, interesting to have you here, hear your insights.
Yep, sure, no issues. Thank you.
That wraps up our enriching discussion with Chetan. From navigating the complexities of open source software compliance to sharing his personal journey and hardships, Chetan's insights have been nothing short of enlightening. If you found this episode valuable, don't forget to subscribe and share it within your network. Thanks again to our listeners for joining us on Let's Discuss Cafe. And a special thanks to Chetan for his time, expertise, and sharing his side of story. This is your host Avinash Tripathi signing off. Until next time, stay curious, stay caffeinated.